says Paul Zuravel. You each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. And if you just let me know, then I will keep track of your time for you.
Thank you, Judge. We would like to reserve 5 minutes, please, if you will.
And we're only 1 minute early. I assume everybody's ready to go. Okay.
Very well.
Thank you.
Thank you, Your Honor. May it please the Court. I'm Seneca Contouros, one of 2 attorneys representing Paul Zuravel in this matter, the other being Mr. Don Marsick. The matters before the Court primarily on the charge of criminal trespass for which Mr. Zuravel was found guilty in a trial in Stowe Municipal Court. There was a preceding motion to dismiss that was overruled by the Court, and that is really sort of the crux of the argument that we have here today and the position that we would put forth before the Court. Ultimately, the brief facts leading up to this were a letter that was delivered by the mayor of Stowe to Mr. Zuravel restricting his access to City Hall. He had some plans, some civil plans that he was looking at having the zoning department work on there. He was getting no response. He went in to try to get a response from them and was met with some resistance. On their end, they believed that there was a bit of a disturbance, and that was the premise for the issuing of the letter. Now, the letter itself, we believe, violates the U.S. Constitution in 2 regards. Number 1, under the 14th Amendment, it poses a due process violation, as there is no opportunity for Mr. Zuravel to argue the issuance of the letter or the restrictions imposed by the letter. Secondly, the result of it is a First Amendment violation, wherein his ability to address the government for redress of grievances against him, or to peaceably assemble at City Hall, or to voice his opinion, have all been completely restricted. And it's on this basis that the First Amendment is violated. Arguably, it could be seen as a time, place, and manner restriction. However, the 3 prongs under that restriction failed to be met and were violated by the terms of the letter. Number 1, obviously, being a restriction on the content of the speech. The letter effectively quashed all of Mr. Zuravel's speech. It was not content neutral. It was content specific, relating just to his speech itself. And then in terms of being narrowly tailored, it was not narrowly tailored at all. It was completely overbroad in that it restricted all of his speech. The other portion is the 14th Amendment violation to due process. The letter was issued by the mayor, and we've argued in our brief, and we believe the position, that the mayor exceeded her executive authority in issuing the letter in the first place. Stowe's city charter provides that the mayor effectively is the CEO of Stowe. She makes sure that everything works properly within the administration. Within that charter, there's an opportunity for her to present items for legislation, items for municipal codes to be considered and put in place. Nowhere within the current municipal codes is the mayor granted the authority to issue a letter or issue any type of restriction on the citizens of Stowe to restrict their access to City Hall. Yet that's what she did. On this basis, that is overreach, because while it is within the mayor's oversight and power and authority to make sure that all laws of the city of Stowe are adhered to and that all laws are followed, there was no law in this regard. So her issuance of the letter in the first place was an abuse of executive power.
How about her role as public safety director under the charter?
So her role as public safety director under the charter places her in a position of authority over the hiring, firing, management of the police force of Stowe and the executive branch on that side. She does not have control over the law department other than in a tangential, ancillary manner. In fact, that's, I believe, Ms. Sipotowski's position is as law director for the city of Stowe. A letter such as this, coming properly from the law department, may have been more proper than coming from the mayor herself. However, the mayor does not have that authority to issue unilateral proclamations that restrict someone's access.
And that's what I was going to follow up with that, and you intimated that what you indicated, the law department maybe, how would you ordinarily handle the situation? A disorderly and call the police and then go through the court system with some type of restraining order? Would it have to be reasonable in scope?
Absolutely, Your Honor. There were multiple avenues available. You named three of them. Or I lost count, maybe it was two.
That's all right.
You mentioned a third, I think civil protection order, you
Correct.
mentioned in your brief.
Yes, and there are absolutely valid legal channels through which the city could have restricted Mr. Zuravel if they believed he was a threat. I believe the police were called to the incident.
Can I back up? Didn't they believe he was a threat based upon the alleged CCW language?
Well, I believe that's a matter of opinion, Your Honor.
It is.
Which,
I'm just saying, I said based upon
yes,
the language.
absolutely. And I believe that to that exact point, that's why the police were called to the scene. And ultimately, in this instance, even where the CCW language was allegedly uttered in the confines of City Hall, no criminal charges followed. And on that basis, that is the other underlying point to which there is no basis for this letter, and this is an abuse of executive power. Because to Judge Carr's question, had there been a particular threat in mind, or one that they felt action was deserving of, there were multiple legal options that they had to follow. And certainly a police report, an investigation, criminal charges, any of those could have been followed. They were not. A restraining order could have been filed. It was not. A protection order could have been filed. It was not. And on that basis, the letter itself cannot unilaterally impose the same sanctions that any one or all of those various legal avenues would have. And at least those legal avenues would have allowed Mr. Zuravel the due process that he should be afforded by our judicial system. But that was scooped out from under him, and it was unilaterally decreed that shy of a couple very, very narrow opportunities that he had to contact people there, he was banned from City Hall. And that in itself was the violation, why we believe the letter was improper. And then with the letter being improper, the importance of that, it being void, ab initio from its issuance, one of the elements of criminal trespass for which Mr. Zuravel was convicted is notice. And if notice is not properly given, then his return can't be a violation of the criminal trespass statute. There are the two elements. There is, a reckless entering of the property, and there is without privilege. Those are the two items. In order for those of the criminal trespass statute, in order for criminal trespass to apply, there must be prior notice given. And if the letter was not proper, if it was void, proper notice wasn't given.
Wasn't that a jury decision though? I mean, didn't the jury ultimately conclude that there was no privilege?
Yes, Your Honor, which is why we're standing here.
Well, okay, good.
The jury did review, and the invitation that we believe was set forth, the reasonable interpretation and inference made from the email that Mr. Zuravel received, in his mind was an invitation when he came there. Even arguing, or assuming that the letter, while we're not conceding was proper, but assuming for the moment that it was proper and notice was given, we still believe criminal trespass, the elements of criminal trespass were not met here. Because you've got the two elements, and where he received the letter that said, your plans are ready, we will drop it in the mail if you like. His interpretation of that, reasonably so, was, or you can come pick them up. Give a call, come on in, we've got it here. He tried to respond, he got no response to his response, so he, not recklessly, came to City Hall to ask for his plans, after asking if they'd be left at the front desk. And then the other element of, since it wasn't reckless with him walking through the front door, the other element is, or remaining after being asked to leave. They said, you can't be here, he left. In fact, when the police showed up the second time, they found him outside of City Hall. He wasn't there to cause a ruckus or be disruptive. He was there to get the plans back that he believed he was invited to come back to retrieve. And on that basis, we believe that, you know, the denial of the Rule 29 motion and the manifest weight of, you know, the evidence that was presented at trial on which the jury made their decision, they were a bit, we believe they got it wrong.
5 minutes and 1 second left.
Thank you, Your Honor, then I will reserve that time for any rebuttal. Appreciate it.
All right.
You may proceed.
Good morning, Your Honors. May it please the court. My name is Amber Zibertowski, and I am counsel for the appellee, the City of Stowe. Your Honors, what this case ultimately comes down to is what right does do a public agency or public entities have over their own property, specifically their workplace property. We've heard arguments from the appellant about this letter being subject to strict scrutiny. I would argue that this letter is not subject to the extreme sense of strict scrutiny because there are 3 different types of public forums the Supreme Court has laid out. There's the traditional public forum, the designated public forum, and the limited non-public forum. That 3rd type is the type that is at issue here. The letter specifically did not restrict Mr. Zuravel's ability to communicate. First of all, it was viewpoint neutral. It didn't restrict his ability to the content of his speech in any sort of way. He could say whatever he wanted. It just restricted the time, place, and manner. Furthermore, this restriction, again, did not restrict any of his rights in a traditional public forum. He was free to protest on or speak on the steps of City Hall outside of the building. He was free to go to any parks. He was even free to go to the safety building where the police department was. He was free to come to any city council meeting. In fact, he did, and speak his thoughts in that sense. What he was not free to do was roam the halls during the normal work hours after he had proven a propensity to disrupt and arguably threaten those employees.
For how long?
For how long?
For how long?
Well, in this case, there was only a 60 days difference. It was 60 days from, more or less, I believe it's May 5th, the time that he was given the letter, and it was July 2nd on the date that he violated the terms of the law.
Well, that's because he, according to the jury, violated. Had that incident not occurred, for how long? In other words, what was Mr., I'm so sorry. Zuravel.
Yes.
What was his recourse?
Well, and that brings to the due process argument. I would argue the due process argument is not an issue here because he did have recourse. He could have gone to the courts, right? He could have filed for an injunction of that letter. He could have asked for a declaratory judgment if he believed that that letter was either violated his First Amendment rights or that the mayor did not have the authority, which I'll get to in a minute, which I do believe she did. But he was not without recourse. Just because he wasn't charged with a crime, because the city chose to find a better avenue to deal with its residents than trying to charge them with a crime, and maybe, let's do something in the intermediate so that we can still have a decent relationship with this individual, yet still address the safety and concerns about workplace productivity. We don't want to put states in a position where they feel like they are better off being harsher and charging individuals when there could be a better when there could be a solution that is intermediate. If you are holding, as the as the appellant would argue, that you have to be charged with a crime first of all, I do believe there was enough evidence that the city could have charged him with disorderly conduct if they wanted to.
Counsel, I just been reading, because my son is doing a project and I'm familiar with it from before, but a letter from Reverend Dr. Martin Luther King from the Birmingham jail where he was incarcerated for violating some laws in regards to civil disobedience. And his theory was that sometimes it's better to be charged with and to violate an unjust law. In other words, you're saying, well, we gave him made that you violated more of his rights than if you had charged him?
Well,
You
if we
took
took,
more away from him, in other words.
well, if we went to that extreme, then wouldn't we, I believe our justice system is developed to err on the side of not charging people. If we were to adopt that rationale, we would always be erring on the side of charging people. And I think you have run the risk of violating many more rights in the long run if we were to take that rationale. And ultimately, that's what this case does. It sets a precedent.
But I don't mean to interrupt you, but you basically said from before, I think you did say, that you could have charged him, but you elected not to.
I believe that there was evidence that could have warranted that. That decision ultimately, was not necessarily with my decision, okay? But that doesn't mean that there wasn't enough evidence to do so. There are many times, for example, we get called out on a different dispute, maybe between neighbors, where there is plenty of evidence to charge one party. But the parties decide, you know what, maybe this is better to handle in the long run without criminal charges. And we do that, and that's fine, and that's what we want in this society. We want to be able to resolve things without having to arrest everybody for every infraction that they make, even if there is evidence of those infractions. We want to be able to encourage people to have collaborative, peaceful resolution by holding that the only way in which I don't believe the courts have said. I mean, Adderley versus Florida, it says clearly, a state no less than a private owner of property has the power to preserve the property under its control for the use to which it's lawfully dedicated. I don't believe the law does mandate that. And if we are to hold that the only way that we can preserve the public's property to the use in which it's intended is to charge someone with a crime, you're going to see a lot more crimes happening over things that could probably be resolved in a much better way. And in this instance,
But with your scenario, then if he feels that his right to access, public buildings and to exercise his First Amendment rights, to lawfully petition the government, all those things, he would have to file a court case himself, is what you're saying, in order to contest that.
I'm saying, yes, that is one way he could do it. He's also, he could, yes, he could come in, he could complain to city council too. City council could, effectively, at the time, there was no city council law about how and when the employees under the mayor shall exactly serve their customers. He was free to go to a city council meeting and he could freely ask the city council to make such rule. That could possibly, you could argue could have overturned that. He didn't do any of those things.
But if it's, I don't mean to be argumentative with you, and I'm not trying to be.
Okay.
I'm just trying to understand this. But if it's an executive power, which is what you're arguing, I'm not sure city council could do.
I believe it's an executive power because city council didn't exercise any legislative authority in this issue. It is, and it also falls clearly within her powers within section 304, where it talks about the mayor has the ability to supervise the administration of all the affairs and conduct. That includes the areas to where her employees work, which is during those working hours. Again, keep in mind, he was not banned from City Hall. That was not what happened here. He was permitted to come to City Hall for any public meeting. In fact, he did. He was permitted to come to City Hall with an appointment. In fact, that's all he had to do was call to ask for one. There's no evidence that he was ever denied that ability. And he was also able to contact any of his elected officials at any time. City Hall, I should point out, is a different kind of building. It's not like what you have here, where you have a separate guard and you have a separate issue where you have glass for where a clerk could be. This is an extremely open building that was built in the 1980s. There is no separate secured areas. Once you are in, you are in. There's no way to save employing essentially a separate police task force, which is a huge burden on a government. There is no other way to really make sure that individuals are securely in that area. So this was the best way to handle Mr. Zuravel's behavior. And the way that the city would be able to make sure that he still was able to access City Hall, he was still able to get everything he needed to get done. There's been no argument that he wasn't able to speak, that he wasn't able to express his concerns, that he wasn't able to get the work done that he needed to get done at City Hall. That's never been alleged. This is just the time, place, and manner based on his disruptive and possibly threatening behavior, which the jury found and believed to be true. Now, going back to the issue of privilege, which we did talk, which the appellant did mention, I will note that, the disruptive behavior, the jury clearly found that his behavior was disruptive to the individuals at City Hall. No less than 7 employees were involved in dealing with Mr. Zuravel that day. We have at least 2 that said that they personally feared for their safety based on his comments of a CCW and his angry demeanor and his behavior that did not relent, despite being told at the first time at 10 a.m. that his request could not be completed that day. Went on for several hours. His behavior clearly made it so that at minimum, it interfered with the lawful use of that building, which is people completing their work. If we hold that that is not what happened and that it was against the manifest weight of the evidence to do that, first of all, it discounts what the jury found. And second of all, we're setting this precedent that it's okay to come in and harass and disrupt a workplace just because it happens to be a public employee workplace. I can't imagine that this court would find it okay for any individual to just come in here and say, oh, I want my case to be heard right now. Well, no, I'm sorry, it's not scheduled. I don't care, I want it right now. I don't believe this court would be able to function if that precedent were set, that that was okay behavior and that you didn't have the power to be able to restrict an individual from doing so.
I have a little different role though, we can issue intent.
That is true, Your Honor.
Just giving you her.
Yes, and I hope you don't do it towards me. Yes, Your Honor. But, and also to the last point about whether or not that privilege was reinstated or whether or not he was given consent to enter City Hall by Mr. Kurtz's email. First of all, the jury did not find that. They did not believe that that was the case, obviously, because that's, they convicted Mr. Zuravel. But part of that reason is, that isn't a reasonable reading. If we can put it in the mail for you if you would like, or we can email it to you possibly, or you can pick it up per the terms of the letter at the law department. Those options were all previously explained to him. If he was invited to City Hall, he would have been invited to City Hall. He was told about an appointment. We all know an appointment concerns 3 things, right? The date, the time, and the place. None of those things were discussed. I also believe Mr. Zuravel knew that he wasn't being invited because he didn't answer that email with a statement, okay, I'll be right over. He answered it with a question. Can I pick it up? Question begs an answer. There was no answer. He was not invited, and he knew it. He was reckless, I'd say knowingly he came to City Hall, knowing that he was not permitted to be there in violation of the letter, and he did it anyway. Ultimately, I would argue that that's a clear violation of the criminal trespass to which he was charged, and I would ask that this court uphold the lower court's conviction and Judge Coates' decision to deny the motion to dismiss. Thank you.
I haven't seen the letter, but does it contain a period of time? In other words, was the ban, for one of them, reluctant to use it?
Yes, we-
Was it an indefinite ban, or was there a period of time where?
It was until,
permitted
the letter said until further notice, and at that time, the reason is, how do you determine when somebody is not a threat anymore? There isn't a.
How would you? How would he let you know? How would?
The only thing that I could say
If I'm
is.
kicked out of school, I get the hearing if I'm kicked off my job as a police officer, I get a lot of
Right.
wondering, what was he to do?
Right. Well, first of all, let's keep in mind, no rights were, in our argument, no rights were violated. He was still able to come and speak and get all of his services that he needs. So I don't know if there really is a need to due process when you've not been deprived of a right. But even beyond that, he could have still contested via the courts, or, keep in mind, you build trust back in a relationship. Again, to go beyond, this is beyond the evidence, a year has gone by, that letter has since been lifted. Mr. Zuravel is permitted in here.
And of course, we're not allowed to fix it.
Of course. But the idea is you.
Along the lines of reasonableness as to time.
Reasonableness as to time. Well, it was within 60 days that he violated the letter, so I would not say as applied in this case that that was an unreasonable period of time. 60 days is only 2 months, and in between that, he had been able to be in contact with city officials and get every services and be able to utter every speech that he needed to at that time.
Thank you, Council. You still have 5 minutes remaining.
Thank you. Good morning, Your Honors.
Good morning.
I have to say, I left Common Pleas Court this morning, and it was a very lonely and sad place.
Oh, thank you. So you wanted to make sure you had a case over in the Court of Appeal so you could see the former trial.
Exactly,
They
yes.
kept telling us we wouldn't see anyone, and yet here you are.
Thank you again, and good morning. These are interesting times that we live in, politically. And this case perhaps takes on some of those conversations. What I look at and I see is democracy is messy. It is complicated. It is sometimes frustrating to the individuals who are a part of it, but it is what separates us as the greatest nation in the world. And I appreciate and respect and understand what Ms. Zubratowski is indicating to this court. Well, what are we supposed to do? We have this public forum and we've got this guy who's causing problems. What are we supposed to do? We were nice to him. We didn't charge him. We could have charged him, but we were nice enough not to do that. And there's lots of situations, and I know this court knows better than I, where police and prosecutions elect not to file criminal charges. But it's more than what happened here. They decided not to file criminal charges, and I would contest that there wasn't enough evidence to demonstrate beyond a reasonable doubt that Paul Zuravel had violated any laws on April 30th. But it's not like when the police go out and they see a domestic disturbance and they talk to the individuals and they decide not to charge anyone. What happened here is similar to the police going out, seeing a domestic disturbance, and saying to one of the individuals, look, you have to leave this house, and you can't ever come back here. You can't see your children. You can't come to this house. You can't contact them. And if you do, we will charge you with a crime. An indefinite ban. And that's what this letter was. An indefinite ban. There's no time frame. There's no 60 days, no 90 days, no 1 year. No built-in mechanism for Paul to do anything to say, wait a minute, this doesn't seem fair. And we've talked about lots of situations that are very similar to what happened here, such as someone walks into this building and is disruptive. And as you said, Judge Carwell, we have different rules here. We have contempt of court. And if someone is found in direct contempt of court, what happens? They're entitled to a hearing, they get an attorney, we have due process involved. Now that may be messy and it may be difficult, but it's what separates us from the other judicial systems in the world. So, in this situation, Paul shows up in response to an email. He's not there more than a minute, perhaps, and the panic button is hit. The testimony was uncontroverted. He was not causing a disturbance. He was not threatening, he wasn't loud.
That's not what he really charged with, though, right?
Well, you're right, Your Honor. He's charged with criminal trespass as a result of that. But
And the argument is, course, assuming that that letter is valid, the argument is that he was told, this is what you can't do, and that's what he did. And an email just saying, we've got your plans ready, we can put them in the mail, is that recklessly that he decided that was an invitation to go down to City Hall and give them himself?
Exactly, yes. And, you know, again, I know these facts are in the record and I know you've reviewed them, but he did wait 40 minutes. It's not like he sent the email and got in the car and ran over there. He was waiting for 40 minutes, didn't hear a reply. So I think it's not unreasonable for him to assume he was allowed to be there. The privilege,
He had, the instructions, what he's supposed to do is contact the state law department.
yes,
Could have called up the state law department and said, hey, they're supposed to have my plans, I want to get those are important to me.
correct. And the letter also said you can come in by appointment. So I think you can construe reasonably the email saying, hey, we've got these plans, do you want to put them in the mail? And he said, I'd like to come pick them up, or can you put them at Teresa's desk as an implied consent to be there, an implied privilege?
For what appointment, exactly?
To pick up the plans at Teresa's desk?
Is that how you go to the doctor?
No, no. But the question is, was he being reckless in being there? It's not how I schedule my doctor's appointment, and it's not how we do that. But under these circumstances, the state has to prove beyond a reasonable doubt that he was at least reckless in doing so. And I think in that regard, they failed.
Council, you're out of time.
Thank you.
Thank you very much. Thank you, all of you, for your presentations. It was enjoyable to have you all here today and make such nice presentations. And we will take the matter under advisement, issue a written opinion that will be sent to both sides. And you can also look on our website.
Thank you.
Thank you.
Thank you.